In a previous video, I described the process of progress claims under contract law. In this particular video, I'll be talking about progress claims as described under the Act, the Security of Payment Act. Now, the important section in the Security of Payment Act is Section 8, and that's the section that specifies that a claimant that makes a claim for a progress payment is entitled to receive such payment. The claimant in this case is usually your contractor, i.e. the builder, or it can be a subcontractor making a claim against the main contractor. Now, prior to the 21st of October 2019, there was no need for the claimant to specify in the progress claim that it was a claim made under the Act, under the Security of Payment Act. But after 21st of October 2019, it was made a requirement that such a sentence be inserted in the claim. What is included in the claim? Well, the Act specifies that the construction works that have been carried out plus the value of the claimed work has to be included as part of the progress claim. And in the case that a head contractor is making a claim for payment, they have to include as evidence, as supporting evidence, they have to include the fact that they paid their subcontractors any amount that they owe. Now, as I said, the claimant makes a progress claim under the Act. It has to be mentioned that the claim is made under the Act. What happens after that? Well, after that, the claim is received by the principal. The principal has 10 business days. That's a time frame that's specified by the Act to respond. Now, the response has to come in the form of a payment schedule. So the principal has to respond in writing via a payment schedule. And the payment schedule would describe whether the principal agrees or disagrees with the amount specified. In the case that the principal doesn't reply back or doesn't send through the payment schedule within the 10 business day period specified in the Act, they become liable for that amount of money that was claimed by the claimant, and the claimant in this instance can recover this amount as debt in court. What about if the principal issues a payment schedule where they disagree with the amount that was claimed? In this case, the contractor, the claimant in this instance, has to submit an application, an adjudication application, to resolve the dispute. Section 9 of the Act describes how the amount of progress claims need to be calculated, and what it mentions is that it has to be calculated in accordance with the original contract that was signed between the two parties. So the contract need to have provisions that specify how progress claims are to be calculated. If there are no provisions that exist in the original contract, then it would be implied by the Act that the amount would be based on the market value of the construction works that had been undertaken by the claimant. Finally, when are progress payments made? They're usually payments are usually made in installments. Remember, you've got a construction project with a large contract sum, so this big sum is divided into installments. And as I'd mentioned earlier, the installments depend on the value of the works that have been undertaken. Usually it's about once a month that a payment would be made. However, if the contract does specify a different time period, let's say, for instance, every 2 weeks, then the parties would stick with provisions that had been described in the contract itself. Now, one final point that I need to mention is that, as I'd already stated at the start of the video, the Act overrules the common law. And this is specifically when it comes to timeframes. So timeframes available for, let's say, for instance, for the principal to pay the amount that they owe to the contractor. In cases where, let's say, for instance, it's mentioned in the Act that the principal has to pay within, let's say, for example, 20 business days. If they had a contract, the original contract stated that payment was to be made within 30 business days, then you'd have to stick with whatever the Act says because the Act overrules the common law. However, when it comes to payment schedule, so whenever the payment is scheduled, if the original contract specifies that it's every 2 weeks, then you'd stick with that provision that's specified in that contract. So you can think of the Act as sort of acting to protect the interests of contractors, subcontractors that are making claims. And if these interests need to be protected by abolishing certain provisions that had been specified in the contract, then the Act would do so.